Hello students, welcome to KANISHKA IAS. This is Reddy. In today's video, we are going to discuss about an important topic, that is Article 142 of the Constitution, where the Supreme Court has a power to grant complete justice. Before we understand what is the meaning of the complete justice or essence of the complete justice, let us also understand what is the distribution of powers in the Constitution of India. In fact, the Constitution of India does not give the sovereignty to single institution. Rather, in India, the Constitution itself is sovereign. That's why we can see supremacy of the Constitution. The Constitution creates legislature, executive and judiciary and other organs, and itself distributes the powers among all these organs. And no organ is literally powerful over the other. It means legislature is not subordinate to judiciary and judiciary is not subordinate to legislature. That's how we can see the arrangement. Moreover, the Constitution also works on the principles of checks and balances. Okay, it means if one organ overrides or creates any overreach or violates the Constitution, the other organ can come and rescue the Constitution. For example, judiciary has to perform the functions only within the limits imposed by the law. We can say it is a procedure established by law. Similarly, executive or legislature cannot bring any legislations or laws, rules, regulations in violation of the Constitution. That is given under Article 13 Class 2 of the Constitution, read with Article 13 Class 3 of the Constitution. But very surprisingly, Article 142 of the Constitution has given literally unlimited power to the judiciary. Even in the Constituent Assembly, when the discussion was taking place, whether the Supreme Court has to be given the powers under the Article 142 or not, there was no single opposition that came up in the Constituent Assembly. Except Thakur Das Bhargava said that this Article 142 is having the relation with Article 136 of the Constitution. Except that no opposition has come in the Constituent Assembly. So it means there was a kind of unanimity or consensus in the Constituent Assembly regarding providing Article 142 of the Constitution. Then let us understand what is this complete justice. In fact, the very purpose of the Constitution is to provide justice, that is given in the form of preamble. Justice is defined in terms of political, economic and social. Even Article 38 of the Constitution envisages the establishment of the social order, having social, economic and political. That's how justice assumes the most important aspect under the scheme of the Constitution of India. That's why after the very statement, that is a declaration of India to be sovereign, socialist, secular, democratic and republic, the immediate objective of the Indian state was mentioned to be justice. Then who has to confer the justice? This political system has to give the justice. Why? Because the very purpose of the Constitution is to provide good life to the people, addressing the grievances. There are different sections of the population having different concerns and considerations and grievances. For example, women have faced suppression. Dalits have faced exploitation, tribals have faced alienation. Every community has their own grievances. So these are to be addressed by the state by providing equal opportunities and by addressing or eliminating the barriers the people generally face. In this context, legislature is the agency which is supposed to make the laws to overcome all these difficulties the people face in the course of ensuring or enjoying the opportunities in the society. Because without enjoying the opportunities, they can't be contributing to the society, nor they will be able to realize their full potential. That's why legislature has to create the opportunities by means of laws. Legislature has to redress these grievances by providing proper policy support. In case if the legislature or executive fails to provide the policy, usually judiciary has no role to play with respect to providing such policy solutions. But Article 142 of the Constitution is giving such opportunity to the judiciary, wherever the laws, rules and regulations leaves the gaps, or if there is any absence of the law, absence of policy, so that the problems of the people are not being addressed. In that context, the judiciary has the power to fill those kind of gaps by means of giving decrees or guidelines. This particular power is called as power to grant complete justice. In fact, the power to grant complete justice is not naive to the Constitution of India. It was already present in the Government of India Act of 1935. That is the Federal Court. And moreover, the same power was vested with the Privy Council of the UK. So that's why this power is considered to be the most important power that is to be vested with the judiciary to overcome any kind of policy gaps. So hence the constitution never leave any scope for the failure of the state, because state cannot be leaving the problems of the people unaddressed. So judiciary is able to fill that particular gap by means of Article 142. The popular example or prominent example for this exercise of Article 142 is nothing but Vishaka guidelines. When women started flowing to the workplaces after the liberalization, privatization, globalization, naturally LPG has created a lot of opportunities. But in this course, the social asymmetries, the social issues like patriarchy and other reasons started in conflict with the women's rights. So hence women has faced the problems due to the sexual harassment or other issues. Eventually their dignity is violated. But there was no such law to fix the responsibility on part of the employer, and there was no such law which will be able to channelize the grievances of the people to get a kind of systematic solution. That's why Supreme Court in Vishaka versus State of Rajasthan has given guidelines which started enjoying the statutory status till 2013. You just understand. Judicial guidelines assume the shape of a statute. Is this ordinary power? No, certainly it is extraordinary power. Fundamentally speaking, this is a kind of a departure from separation of powers. Moreover, Supreme Court in Aruna Shanba case also reiterated the same kind of stand, where judiciary is granted passive euthanasia. Even today, there is no such law will be regulating passive euthanasia. So that is the scope how the judiciary is able to ensure the protection of the rights of the people and observing the principles of the constitution in the course of the governance of the country. Thank you very much. Please keep watching KANISHKA IAS, Mission UPSC.